Next up on This Week in Law, Emory, Roane, Declan MCCULLAGH, and Eric Goldman join me. We'll talk about Crypto Wars Part 2, anonymity and identity on the blockchain, new proposed laws protecting trade secrets and consumers, and much more on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise HOWELL and Emory, Roane, episode 334, recorded January 22nd, 2016. Warrant, Canary in a law mine. This episode of This Week in Law is brought to you by Blue Apron. Blue Apron will send you all of the ingredients to cook fresh, delicious meals with simple step-by-step instructions right to your door. See what's on the menu this week and get your first 2 meals free by going to blueapron.com/twit. That's blueapron.com/twit. And by PillPack, a full-service pharmacy that combines convenient packaging, modern technology, and personalized service to make your life easier. Visit pillpack.com/twit to save $20 on vitamins and OTCs when you transfer your prescriptions. And by FreshBooks, the super simple cloud accounting software that's giving thousands of freelancers and small businesses the tools to save time billing and get paid faster. Try it free at freshbooks.com/twil. Hello and welcome to This Week in Law. I'm Denise HOWELL. I'm here with my co-host Emory, Roane. Hello, Emory.
Hey, Denise. Thanks for having me back on the show. Glad to be here.
Great to have you. Emory, in case you don't know, is our intern here at TWiL and also at the Privacy Rights Clearinghouse. And he's a second-year law student at California Western School of Law. Great to have you back.
Yep, thanks.
We have 2 awesome guests today. In fact, one of our guests is officially known as Never Not Awesome here on TWiL, and that is Professor Eric Goldman from Santa Clara University School of Law, where he teaches and also runs the High Tech Law Institute. Hello, Professor Goldman.
Hi, Denise.
Great to see you again. For those of you who have been longtime viewers or listeners to the show, Eric started with us, I think, when we were only having listeners and not viewers. We just checked back in the archives and found out he's been on the show. Is this your 15th time or is this the 16th?
This will be the 16th.
The 16th, and joined us as early as episode 10, which I think was before we were actually doing video on the show. So it's great to have you back. It's always great to have you back on the show. And definitely one of our most popular guests. We always hear from people talking about how wonderful it is that you give us so generously your time and insights here on This Week in Law.
Oh, it's so much fun for me. But I didn't get any coffee on this one, so...
Oh, no. Well, maybe we were talking about having Amazon drones fly in with them, exactly that product for us during the show. So we'll try and set that up while we're going here. Also joining us is one of my very favorite former journalists, and that is Declan MCCULLAGH. Declan, for the longest time, was a writer at CNET. Declan and I used to subscribe religiously and read your Politech newsletter, and Declan speaks and opines on law and tech and policy issues all over the country, if not the world, and is also now pursuing his passion for writing code, and has a startup in the works called Recent Media Inc., which is a wonderful personalized newsreader app. So Declan, I'm so thrilled to have you on the show.
Well, thanks for having me. This will be fun. I'm not following the topics the same way I did as a reporter. Now I'm following them as a startup founder and what they might mean to me. So maybe I can speak from that angle as well. But thanks again. I'm looking forward to it.
I hope that you will. We definitely have some good privacy topics in the show this week, and I'm interested in picking your brain on some of those things from a startup founder's perspective. But before we get round to those, I think we'll start with some stories that impact Section 230 of the Communications Decency Act, which is so pivotal to the social web. Eric was pointing out before the show that Twitter has recently been hit by a lawsuit by the survivor of someone who was killed by an ISIS terrorist attack. And they are pursuing Twitter on the theory that Twitter somehow aided and abetted this attack by permitting terrorists to organize and communicate with one another, recruit, etc., using the platform. I will let Professor Goldman tee this up a little better for us. It might not be that intuitive why Twitter might have immunity from that kind of lawsuit, but I think it's very clear that there's a strong possibility that's the case under Section 230. Can you explain why, Professor Goldman?
Yeah, so let's start with the tragedy here. As we know, ISIS has become the new face of terrorism for us and across the globe. So we have a full court press by our government and many other governments to shut down ISIS any way, shape, or form. That has included an extensive amount of discussion about the role of social media in helping terrorists run their business, especially with respect to Twitter and ISIS. The perception among our government is that ISIS is particularly social media savvy. And so they're using tools like Twitter in order to reach new audiences and evangelize their message. I must say I'm a little bit skeptical about that. I haven't seen that particular empirical claim well documented. But let's just stipulate for a moment that ISIS uses Twitter, that they are social media friendly, and that that's somehow advancing their terrorist objectives. Now what? Does that mean that companies like Twitter, who provide a platform for conversations by terrorists, non-terrorists, and everywhere in between, are responsible for all the deaths that are caused by ISIS? That's kind of the thrust of this particular lawsuit. And that's where we start to really question, wait a minute, how did Twitter cause this death? Or what is Twitter done that causes the problem here? We have a federal crime that says it's illegal to provide material support to known terrorist organizations. And let's assume for a moment that ISIS meets that classification. The real analytical question then is, what did Twitter do that provides material support to terrorists? And the answer is they allow people to talk to each other. That's the only contribution that Twitter brings to this equation. And Section 230 says websites aren't liable for third-party content. Holding Twitter liable for ISIS talking to its actual or prospective members or to the world at large seeks to hold Twitter responsible for the messages that ISIS is disseminating. And Section 230 applies. It's really not a close question. We have to get around the fact that ISIS is the bogeyman and that somehow provide material support to terrorists is somehow different than publishing content, when that's actually all Twitter does.
So the part of Section 230 that jumps out at me as important in this analysis is the part where it carves out immunity for the criminal acts or the intellectual property violations of communities or web services users. Here, the criminal acts exception being prominent. Do you think that there is an argument that ISIS simply by talking to the public is engaged in a criminal act?
So the actual language excludes federal criminal prosecutions from Section 230's coverage. So if the Department of Justice wanted to prosecute Twitter for materially contributing to a known terrorist organization, then Section 230 would step aside. That prosecution would almost certainly fail for other reasons. Among the most obvious would be the First Amendment defense. But Section 230 would be irrelevant to that. But all other ways of trying to hold Twitter legally accountable for this alleged federal crime are preempted by Section 230. And we've had a number of cases, at least a half dozen, where plaintiffs have brought civil lawsuits predicated on a violation of a federal crime, and Section 230's exclusion for federal criminal prosecutions doesn't help them. And that's exactly what's going on here. We have a civil lawsuit predicated on the alleged commitment of a federal crime.
So only the government would have standing to go after Twitter for this if it thought that a federal crime had taken place using its services.
Correct. Or stated differently, only the federal government gets a free pass around Section 230's protection, saying websites aren't liable for third-party content. But the federal government isn't likely to win this case anyway, and probably wouldn't even choose to bring it for that reason. So if the federal government can't bring it and private plaintiffs can't bring it, then it just kind of ends the discussion.
Declan, do you have any thoughts on this sort of strategy to get at a private web service for the actions of its users?
Well, as Eric knows, this has been going on a long time, and this is one reason why we have 230 in the first place. I view it as a deep pocket strategy. If companies have valuations in the billions of dollars, or in the case of, say, Apple and Google, billions of dollars, tens of billions in the bank, then you're going to have creative plaintiffs trying to find a way to extract the money from them. As a practical matter, I mean, I'm a little worried about what this means, not just to companies like Twitter and Silicon Valley public companies that have or lawyers on staff and can retain a very good trial counsel. I'm also worried about what it means to the smaller startups that hopefully will become these big companies one day, like mine. I mean, we have a news recommendation engine, an iOS and Android app. What happens if we get sued by this kind of what I would call a vexatious lawsuit? What happens if we're indexing sites that are in theory favorable to ISIS? Maybe we're indexing Al Jazeera English, which we do. What happens if ISIS users are actually downloading and installing our app? How do we try to cut them off if we know or have reason to believe they're using it? I mean, this is a can of worms, and it's going to be very difficult for companies in the tech space that are trying to serve an entire globe of users to do this kind of policing. I'll support a broad reading of Section 230 in this case.
Emory, you're closer to your law school torts class than some of us on the show and many folks listening. And Eric started this conversation talking about causation. Do you see a parallel here between cases where courts have decided the causal link was just too tenuous? One flavor of case that comes to mind are cases against gun manufacturers who have tried to hold them liable for the acts of their users.
Well, you are calling me out on this one. Torch was a whole semester and a half ago. You must give me a little bit of leeway here. But,
yes.
I think that Declan and Eric both hit it on the head. This sounds like exactly the sort of thing that Section 230 was created for. The causal link, it does seem really, really tenuous. And, Declan's example lined it up exactly right. This is what the Section 230 is for. Whether or not ISIS is the current boogeyman or not, I think that it's pretty clear that the Twitter should not be held accountable for materially supporting ISIS simply because the platform is being used by their members.
Hey, Denise.
Yes.
I would add, actually, we have seen a case that might also be relevant here, a case where a gun e-commerce site allowed the sale of an illegal sale of a gun that was used to murder somebody. And the court actually didn't rely on Section 230 case. It simply said that the case failed on its basic tort principles. So even if Section 230 weren't applicable here, if this were styled as something like a negligence claim, we have other precedents saying that it should fail as well.
Right, and since you're our professor on the show, Eric, and Emory's a whole semester and a half away from torts, maybe you can explain for our non-lawyer listeners how close that causal link has to be under the core tort law cases.
Yeah, actually, Emory is probably more knowledgeable about tort law than I am because I'm a law professor. So I don't actually know what the law is. It's whatever I say it is, and that changes from day to day. But actually, if you read the complaint, the causation issue should jump out right away at any reader. You'll see that the complaint introduces a bunch of things about how bad ISIS is. It talks a little bit about the death, and then it talks about Twitter and how popular Twitter is and how ISIS is using Twitter. But when you read that, you say, okay, I see that ISIS is bad. I see a death. I see that Twitter was allowing ISIS to communicate. But how were the communications on Twitter at all related to the death? What was the connection whatsoever? And I think anyone who reads that complaint is going to have the exact same reaction. ISIS is bad. Twitter allows them to talk. How is that related to a death? The plaintiffs didn't even try to establish the type of causality we would expect here. We would require the plaintiff to show, if we were establishing a negligence claim, we'd require them to show not only actual causation, but what we call proximate causation, the but-for causality. And I just don't see it here because Twitter allowing people to talk is not, is so far removed from the chain of events that cause the actual death. The only thing I will add is that the plaintiffs were focused on this material contribution to a Twitter or to a terrorist organization. So this is not a standard negligence claim, and so some of the causality kind of fades into the background, perhaps. In theory, it's illegal to support a terrorist organization, even if that terrorist organization never causes a death whatsoever. Having said that, in this particular case, because it's not the government prosecuting it, the causality issue just jumps out at anyone.
Do you think, Eric, that there's actually more chance of maybe a gun manufacturer or someone who facilitates the sale or acquisition of a gun, whether it's a conventional one or maybe a 3D printed one, that there's actually more chance of them being held liable for civil damages of the kind sought here than there is a platform like Twitter?
Well, yes, because of Section 230, but I think you're asking something a little more subtle than that. But, if Twitter is responsible for this particular death, think about all the other contributing factors that allows ISIS to run its operation that contributed to the death. We obviously have the gun manufacturer and the ammunitions manufacturer. We have the internet access provider who allowed ISIS to connect to Twitter. We have the power company. We have the vehicle manufacturer who sold the car that ISIS used to drive around, and so on. In other words, we're used to in the law drawing some boundaries around responsibility for some bad action and saying that many of the items in our society are just neutral or not designed to contribute to a particular outcome and therefore aren't responsible for that outcome. So the idea that Twitter is a material contributor to the death seems even more remote than the gun manufacturer contributing to that death. But the gun manufacturer probably had zero control over how that gun was used. And as a result, they actually are pretty similar to Twitter. Neither one really could have prevented the death without completely changing their business.
There's also, Denise, if I could jump in 2005, President Bush signed into law immunity for gun manufacturers and gun dealers. I think it's called the Protection of Lawful Commerce in Arms Act. And so it immunized them from negligent lawsuits based on the negligence theory, unless the product was defective or something like that. And so Congress made a decision on what to do here.
Right. All right, Eric, before we move on to some more ISIS and terrorist-related concerns that may be driving policy and tech company architecture, there's one other interesting Section 230 case that you just recently wrote up that involves a case. It looks like the court here, your opinion is the court here got it wrong and didn't apply Section 230 to the forwarding of a screenshotted tweet. Can you tell us about that one?
Yeah, actually, although Denise, when you said before we leave ISIS and Twitter, I thought you were going to say, let's take a commercial break. And you probably could have gotten premium ad rates from ISIS for that particular interjection there.
That's right.
Probably would have been substantially benefiting him.
Yeah,
probably would have been
that might be
supporting
a
ISIS
more
for that,
direct
you know?
material contribution, so I don't recommend it.
Yeah.
So, so we saw another odd Section 230 case, and we do see these every now and then. I blog them, even though I don't really like them, for the sake of completeness. In this particular case, we have a nasty divorce dispute, and someone, we're not sure who, creates a Twitter account that starts saying nasty things about the husband. Things like he has multiple sexually transmitted diseases and that he's a liar and a player and a few other unsavory remarks. So the husband takes a screenshot of that account's tweets, sends it to the wife and says, I can't delete these. I'm guessing either you or one of your cadre did this. Can you please delete it? You've made your point. The wife then forwards that to the husband's new girlfriend and to the guardian ad litem who's responsible for helping the court make decisions about the kids. And so the husband says, well, that wasn't very nice to forward the screenshot. So the husband sues the wife for defamation. The court concludes that the actual tweets weren't defamatory, which we can talk about if you want. I kind of raised my eyebrow at that as well. There were some pretty harsh things there. But the court says that the wife cannot defend on Section 230 grounds, basically saying that she transmitted the screenshot to the girlfriend and to the guardian ad litem, and therefore Section 230 doesn't apply. Both the husband and wife were proceeding in the defamation case without attorneys. So I don't think we had the best advocacy in that case. And that's why I think this case went so far off the rails. We have at least a half dozen cases where Section 230 has applied when someone has received an email and then forwarded on to third parties, and then the email was held or asserted to be tortious, like defamatory. So we actually have a pretty good body of Section 230 law saying that if you get an email from someone else and forward it on, you're not liable for the contents that you forwarded on. But this case held otherwise, even though the wife ultimately won.
All right. Thanks for bringing us up to speed there. Anybody have any thoughts on this case before we move on?
I did sort of think it was interesting. It sounded almost like a tort law professor question because, I think I agreed exactly with what you said in your article that, it sounds like slander per se. There's, talking about loathsome diseases sounds just, pretty much open and shut about slander. But yeah, regarding the improperly applying Section 230, I think nothing to add.
All righty then. We're going to take a break and thank our first sponsor for this episode of This Week in Law. And it's about lunchtime here on the West Coast of the United States. So it's a good time to get you thinking about Blue Apron. You need to know how to cook. Not only will you feel like you know your way around the kitchen using Blue Apron, but cooking at home means eating healthier and saving money instead of ordering expensive takeout again. But where do you start? Blue Apron has you covered. For less than $10 a meal, Blue Apron delivers all the fresh ingredients you need to create home-cooked meals. Just follow the easy, beautiful step-by-step instructions that come with the package. Each meal can be prepared in 40 minutes or less. No more overwhelming trips to the grocery store. No more sad takeout. And no matter what your dietary preferences, Blue Apron makes it a breeze to discover and prepare dishes like chicken and sage biscuit pot pie with cremini mushrooms and purple top turnip. Try saying that one 3 times fast. Or Tuscan robolita soup with soft-boiled eggs and lacinato kale. right in your own kitchen. As you could tell just from those sample meals, they send you all kinds of ingredients that you might not even think to pick up at your local grocery store, that your local grocery store might not carry. But when Blue Apron puts them together, they make just an amazing flavor profile. It's really, really fun. It's almost like magic putting together their recipes in your kitchen, not only for the great things you can produce yourself, but for the wonderful experience you have with friends or family who come over and participate in the process. You might find watermelon radishes in your package. You might find farro. You might find purple potatoes. As I said, they really do scour the globe for wonderful cooking ingredients and have wonderful expertise on putting them together in a way that is both easy to prepare and tastes absolutely delicious. Recipes are between 500 to 700 calories per portion, delicious and good for you. Right now, you can get your first 2 meals free just by going to blueapron.com/twit. Check out this week's menu and get your first 2 meals free by going to blueapron.com/twit. Thank you so much, Blue Apron, for your support of This Week in Law. All right, we're going to move into some privacy stories. So with Declan on the show, I wanted to resurrect some themes that we first explored after the bombings in Paris, in episode 328, where we had a couple of representatives from the Electronic Frontier Foundation on the show, related to encryption and how much of it should be allowed to exist and whether it's possible to compromise it in a way that government, law enforcement can get at bad actors while still enabling people to have rest assured that their communications are secure. The upshot of our discussion with the EFF folks was it's just not possible to backdoor encryption. But if you are listening to any of the conversations in this election cycle, you would see that people in Washington don't seem to agree with that and don't seem to have gotten the memo. So I'm wanting to get the temperature of our panel today, both on what you're hearing from the politicians, what things are being proposed to abridge the security of encryption, and your thoughts on all of it. Declan, we'll start with you.
Wow, I'm now feeling old because I was at Wired and then Time and then CNET back during the first encryption wars. This was back in the 1990s when I was living in Washington, D.C. and covering some of this stuff as a reporter. And I remember, for instance, in the fall of, I think it was September 1996 or 1997, there actually was a House of Representatives committee that approved, only one committee, it didn't go to it didn't get a floor vote, but it actually approved a law that would ban encryption without backdoors for the government. I mean, this was a hot topic back then, and I thought we won. I thought that the forces of light had defeated the forces of darkness and the national security state, and I was wrong. It's back, and we're seeing similar proposals today. I mean, we have New York and California that have what appear to be similar bills afoot that would, I looked at the New York one a few weeks ago. I recall it said that if you're a manufacturer of a device, this is Apple or Samsung, that provides full disk or device encryption, then you're going to have to include a backdoor. And this is just as dumb as it was back in the 1990s. Encryption is a binary thing. It's actually even more binary than, say, whether the right to have an abortion. Either you can or you can't. Or the right to criticize your government, or the right to buy a handgun of your choice. I mean, those you can actually kind of you can imagine some mild versus major restrictions on those rights, but encryption is even more binary. And politicians are trying to finesse this by saying, well, maybe we can protect privacy, and maybe we can also protect security. I mean, you see Hillary Clinton in the forefront of doing this, and I'm sure some Republicans have. they're trying to have it both ways. They're trying to avoid taking a position on one side or the other, but you can't. It's silly. You have politicians who are lawyers who are not technologists, don't have the technology background, and so they come out sounding kind of silly, just like they did in the 1990s.
Right. Eric, do you think almost that folks in the election process here, Clinton and others, are capitalizing on people's ignorance on this front and attempting to make it sound as though, well, here's candidate Clinton's comment from November. We need to challenge our best minds in the private sector to work with our best minds in the public sector to develop solutions that will both keep us safe and protect our privacy. As Declan points out, we have been through this before, and it's not any easier to chart that middle ground now than it was then. But do you think they're almost trying to mislead people that that's the case?
So first of all, Declan was such a leader on this topic in the 1990s, and we're lucky to have his perspectives today. But if we're looking to mix it up with two opposing views, which I know you don't always try to do, but here there's just no chance. Declan and I are 100% on board on this one, I think. So I agree with everything Declan said. And then that raises the question, if it's so well understood in our communities that this is a binary outcome, either you have encryption that works or you don't. And there's no way to slice the baby more finely. Then it makes me wonder, are the politicians naive? Are they engaged in public wishful thinking where they're kind of fantasizing out loud? If we could just have the magical Deus Ex Machina come down and solve all of our problems, wouldn't that be fantastic? Or are they really bought into the entire security apparatus? That really, in the end, what they're saying is, we understand it's binary. We're going to pick security over civil liberties. And if you look at our politicians, and especially our presidents, every single fork in the road we've seen in the last several decades, the security apparatus has won. So I can't tell if they're being disingenuous, if they're being engaged in wishful thinking, or if this is really a way of saying we want more security at the expense of civil liberties and consequences be damned.
Yeah. I don't know. I'm thinking I can clearly fall down on the cynical side. That I think that, this is a fight that was already fought. Everything that isn't that could be said about this has been said 10 years ago. There is no disagreement among experts about whether or not this is possible. It is, exactly as Declan said, a binary thing. And what's more, Steve Gibson over on Security Now, that you guys should definitely check out if you haven't already, watchers and listeners, has said it perfectly. It's math. We don't need to be trying to criminalize math. The knowledge of how to do perfect, very good crypto is out there. And all of this will do is just push the market for people that want to do that illegally into somewhere else. I think that ISIS already has Al-Wahi, the encrypted messaging app. This not only doesn't seem like it would not. This seems like it would not only not capture the bad guys or effectively help security, but it does just undermine civil liberties at every step of the way. Gizmodo had a great article earlier this week that the government, NSA, doesn't need to break encryption to get your records. The NSA doesn't need to break encryption to, access the contents of your electronic communications or your metadata or anything else. They're already doing that. They can go straight to the companies, and only 10% of people right now are encrypting their messages anyways. So I feel like this is disingenuous. I feel like this certainly sounds like they've bought into the security state, if that's what we want to call it. And yeah, I think it's especially disingenuous the way that these remarks are given, because you can't have it both ways. And it does feel like all of the candidates are really avoiding to actually say their position on it. Martin O'Malley actually, surprisingly, I felt like was the only candidate during the Democratic debate when this was brought up that came down and said anything sort of sounding almost close to definitive when he said that whether it's a back door or the front door, a warrant is going to be required. To me, that sounds okay. Very clearly, he's in the camp that we're going to have a backdoor. Civil liberties be damned. So,
hey,
dark
Denise.
days.
Yes.
I'm sorry, I just want to add one more thing that might point us towards evidence that these public statements are disingenuous, which is when we see encryption blamed in mass murders or other terrorist attacks, and before we would know that encryption was involved, and then ultimately when we discover encryption had nothing to do with the attack whatsoever. But we see what seems to me to be an organized effort every time that there's some kind of headline-worthy attack on the population, intimate or say encryption was the cause, even if there's absolutely no facts to support that.
Right. This is 2016. We've already seen this node in Revelations. We don't need to be giving the security/surveillance state any more authority to eavesdrop, in my opinion.
Yes, and the theme they keep raising in the debates, I keep waiting for one of the candidates to come out and recognize the binary nature of the problem, and they don't seem willing to do that. But what they do keep hammering on, and it's a good message to bring out, and I'm sure it does score them points, is this notion of bringing Silicon Valley and lawmakers together so that people can be as informed as possible about how laws should work, what the goals are from a policy standpoint, and what the technology actually permits. That's all well and good, but when you simply can't solve a problem through technology, that should be recognized as well. I think we'll make "Fool Me Once" our first MCLE passphrase for this episode of This Week in Law. We put these passphrases into the show in case you are an attorney or another professional listening to the show for professional education credit. If you'd like more information about that, head on over to our wiki at wiki.twit.tv. You'll find our show This Week in Law there. And if you're a lawyer, you'll find a whole chart of the various jurisdictions and their MCLE compliance bodies and how you can submit for credit for the show. Declan, this is the point at which I wanted to ask you as a startup founder about your approach toward incorporating encryption in your app, if you've thought about it at all. And, obviously you're not presenting a communications app per se, but you definitely have privacy concerns for your users in the way that a library would or a video rental service would. There could be, I could certainly envision a scenario where a law enforcement agency might want to come to Recent and investigate somebody under suspicion of some kind of crime, what they had been reading, what they had been keeping up on. So have you crossed this encryption bridge yourself?
We have, and my co-founder and I are doing things like encrypting all connections to our backend server. We use Google App Engine to host our recommendation engine backend. By the way, let me back up a little. Recent is an app that is available for free for iOS and Android, both tablets and phones. And if you use it, we'll start to recommend some news. I think we do an amazing job. I think it's the best recommendation engine for news out there. It probably helps that it was created by co-created by a former journalist. And so we do have some information that could be sensitive of what topics you follow, things like that. And so we published a blog post, if you scroll down, you'll see it, about a month ago, talking about the approach that we do, or there it is, December 1st, how recent news protects your privacy. It's about the steps we take to be what I think is best in class in terms of privacy. For instance, you can use our app without identifying yourself or without syncing via Facebook. You can just start using it anonymously, and we'll start giving you recommendations after you read a few articles. We use encryption for the backend. We limit the log store, that is connections to the backend. We limit log storage. We take steps to protect your location privacy. We don't do any background activity. These are things that we think are make us very privacy protective, and also we have what amounts to a Warrant Canary. We do not encrypt the data on the device, except to the extent that the device encrypts it. And so, in other words, if you choose to lock down your iOS device or Android phone, then your user data will be encrypted. We don't do additional encryption on top of that, in part for performance reasons and debugging reasons. But we figure if you care about privacy, you'll be encrypting the data anyway. And so we try to. We spent months doing additional work, engineering work, to make our app very privacy protective. And if we were told you can't use encryption or you can only use backdoored encryption, well, wow. I mean, we use some standard encryption libraries for SSL, or are we going to have to wait until our vendor comes up with new versions of this? I mean, it really seems it would be a compliance and regulatory nightmare for us. I'm not going so far as to say it would put us out of business, but it would really screw us over. So we would be very much opposed to that. And actually, one additional point back to the Rand Paul discussion, he's the only Republican candidate I can think of who actually took a pro-encryption stand, saying this was in May of last year, I think it was, during a Capitol Hill hearing. He was saying encryption is a response to a government that doesn't have a real sense of decency towards privacy. This is when the Homeland Security Secretary was testifying. So at least we have one guy who's on the record saying, and seems to know what he's talking about.
Right. And perhaps you should explain for us, if I could pull out of your answer there, the reference to a warrant canary, what that is.
Sure. We have not received any compulsory legal process from any government agency that includes a gag order, and so that's kind of useless unless it's updated. And we plan to announce in the next week or so the process by which we'll update this statement, which I just made. And is it PGP signed or is it just put on a server? So that's what we're planning to announce. Let me back up. If we fail to update the statement, you can draw your own conclusions. One is that we screwed up and we should be updating it. Another one is that we were served by some sort of gag order that includes or sort of served by a compulsory process that includes a gag order and requires us to snoop on our users. We have not received one. But if I can no longer make that statement the next time I'm on the show, then you can draw your own conclusions.
Right. And for companies following this process, I assume you're posting that somewhere online, and should it vanish, people can draw their own conclusions. Is that how it will work? It's unlikely to vanish. It's more like if we publish a schedule, which we will, and then say on a monthly basis, and then we fail to update that on a monthly basis, then again you can draw your own conclusions. And the most obvious conclusion would be that we were served with compulsory process. And how are you dealing with warrants that you might receive that don't involve a gag order? Will you be publishing a list of those and a transparency report that like other companies have done, that show users what government requests you have complied with when you're allowed to disclose that?
Well, we're only a two-person startup, so publishing a full-fledged transparency report is something that ask me in a year once we've grown large enough to have the staff to do that. But if you look at our privacy policy, and this is where you should be downloading the world's greatest news app, we do say things like we intend to fight any request for user data and litigating it to the best of our abilities, things like that. So we try to be as privacy protective as we reasonably can.
Eric, any thoughts as we conclude the encryption discussion here?
Kudos to Declan for being so savvy about this. I wish that more entrepreneurs were thinking ahead about the demands that the government's going to make for information about their users and ways in which they can either help protect their users' privacy, or at least to communicate to their users what they're doing. So, Declan makes it sound all so elegant and simple, but actually what he's doing is relatively savvy and sophisticated compared to what we're seeing in the marketplace. So I hope others will follow his lead.
I actually have one question.
Sure, go ahead, Emory.
So I'm not familiar with the precedent, but have warrant canaries been defended successfully? Like, that sounds almost like it's a roundabout way of disclosing, which would violate the gag order. Have they been supported in court?
They haven't been tested in court as far as I know. I mean, for all we know, there could be some procedures taking place under seal today, but they haven't been. It relies on the concept that forcing a service or a company to publish a lie would run into some First Amendment obstacles. Maybe these obstacles can be surmounted by saying we have not received any process, and when in fact you had, that would be a falsehood. But in general, I think that warrant canaries will probably survive legal tests because they're pretty innocuous. It's not like we're publishing a warrant canary for every one of our tens or hundreds of thousands of users saying this user was attacked or this user wasn't. We're being, this is just, have we received legal process or not? Have we been forced to re-engineer our services or not? They're very, very broad terms. They're not, we don't have a list of, say, 1,000 different federal crimes and state crimes. Then we're listing little check marks by whether anyone has, we received legal process relating to that crime. That might, a judge might look very, very negatively at that, but just a one or two statement, one or two sentence summary seems pretty innocuous.
It seems like it would just be best practices in the industry now that any company that I would want to buy a product from, I would hope that they would have a warrant canary. I'd be interested in finding out if any watchdog organizations have compiled lists of that or offered, form warrant canaries that companies can use.
Sounds like
the Calyx Institute. You may remember Nick and his work on fighting the NSL, the National Security Letter gag order, with the help of the ACLU. This is Nicholas Merrill in New York. He's published, I believe it's canarywatch.org, but he has a list of organizations with warrant canaries. There are a few, say, file hosting services. We're the first recommendation engine and news app, and I emailed him a few weeks ago, and he said he was going to add us to the list as well.
They're a relatively recent innovation, so it's not like we have a long history here where it's been so adopted that everyone who hasn't adopted would stand out. But I love the idea of making this a metric for the companies that we consider trustworthy. It's such an elegant way of showing some savviness to users about their privacy.
it also sounds like a good project for the Privacy Rights Clearinghouse, Emory.
I had that thought. Thank you. Yes.
Yes.
Add more to Emory's workload.
That's right.
Yeah, no, it's fine. It's the pile. Just add it on. It's okay.
Right. Declan, you were mentioning it's perfectly all right for folks to use your service anonymously, although it's becoming less all right, much as we're seeing attempts to make encryption technologies less available or less secure. Anonymity is something that lawmakers seem terrified of in this day and age as well. You linked recently on Twitter to a story about a Homeland Security official who wants to outlaw internet anonymity. Can you speak to that?
Yeah, this was a Homeland Security official speaking, as far as I know, it was prepared remarks. It wasn't extemporaneous. And the idea was internet anonymity is dangerous. We must ban it. Now, this also goes back to the 1990s. I feel like a broken record here. I remember sitting in a Senate hearing in the late 1990s. I was sitting next to David Sobel, who at that time was general counsel for the Electronic Privacy Information Center. And the FBI director was testifying, and he said, let's ban internet anonymity. And so it's we're coming full circle. And my first thought is, well, okay, where does the Constitution give you the power, the authority to do this? Last I checked, it didn't. That's not exactly regulating internet interstate commerce. It seems like a non-starter from the get-go, though it hasn't stopped Congress in the past. And also, Eric probably knows more about this than I do, but I remember the McIntyre Supreme Court case in the 1990s, and the majority said there was an honorable tradition advocacy and dissent, and when you're anonymously pamphleteering. And I don't see why this should be any different online. And finally, as a practical matter, I remember when law enforcement officials have been using anonymizing services like anonymizer.com early on, or Tor today, and that's in part to keep track of the bad guys. If you're investigating a website that you think is doing something a little suspicious, you may not want to come from FBI.gov. You may want to come from anonymizer.com or Tor instead. And so it's kind of funny that you have Homeland Security on one hand saying, let's ban this, and the other hand saying, oh, well, a different department of ours actually uses this.
Well, presumably there would be a loophole for themselves that we can be anonymous, but the rest of you can't. Eric, any thoughts?
Not for me.
Right.
Yeah, I always find the debates about anonymity and to some respects encryption to be such a red herring, because there are so many different ways to figure out who's doing what, that actually being able to listen in to the full content of the conversation, or to know who is speaking at any particular time, is often just a small piece of a larger investigatory process. And my favorite example about this is the anonymous commenter on a newspaper website who was de-anonymized by linguistic analysis. They were able to figure out who that person was simply by noticing by doing some statistical analyses of the word choices and grammar that the person used. So whenever you hear people creating an anonymity as the bogeyman, I just shake my head and think, I don't really even understand why they're targeting that, given all the different ways in which anonymity is so hard to preserve in practice.
Yeah, it's disingenuous. They know exactly what they're doing. This is a power grab. Yeah.
Got it. All right. Well, we're going to talk for a moment about anonymity and identity on the blockchain. But before we do, we're going to thank our second sponsor for this episode of This Week in Law, which is PillPack. Now, I don't know about you guys, but I take a lot of vitamins and supplements and a few prescription medications that have to come everywhere with me when I travel. And when they do, they generally look just like this, an undifferentiated baggie full of the vitamins and various things that I take. And it kind of works, but it doesn't work great. Oftentimes, as you can see, there are a bunch of things in here. See all those big white pills? Sometimes I have trouble determining whether one is the glucosamine chondroitin that I take all the time to keep my creaky old joints working, or whether one is the vitamin. And so it gets a little confusing knowing what to take when, because medications can look alike. Well, that's where PillPack comes in, and in a lot of other ways too. PillPack was founded by a second-generation pharmacist inspired to use technology and design to fix the pharmacy and deliver a better customer experience. Your PillPack arrives in a convenient, recyclable dispenser. It has one easy-to-read label, which here I'll show you on the back of the dispenser, which actually has a picture of each of the medications so you know what it's supposed to look like. And unlike my undifferentiated baggie, it separates them out into doses, little individual packets that tell you what you're supposed to take on a particular day or at a particular time. So it solves that problem of things looking alike. It also solves the problem of the fact that you have prescription medications, which is obviously what PillPack is designed to do, to be your pharmacy. But you also have supplements that you likely take as well. And I don't really treat those things differently. They're pills I have to swallow. It doesn't really matter to me whether one has come from a doctor and one has come from a shelf. So PillPack makes that easy for you. It pre-sorts and delivers your medications and your vitamins in those little easy-to-tear packets I just showed you. They're individually labeled with the date and time for each dose. PillPack uses robots and digital imaging technology along with pharmacist oversight to ensure the accuracy of every pill pack. People are still an important part of the equation as we talk about time and time again on this show. Advances in automation and artificial intelligence are wonderful and fun to observe, but they're certainly not to the point where you want to be trusting only a robot or digital imaging technology to take care of the important prescription drugs that you take and the supplements that you take as well. And PillPack recognizes that. PillPack's pharmacists are available 24/7 from the privacy of your own home. So you're no longer waiting in line at the pharmacy or having awkward conversations there that the folks behind you can overhear. They also proactively call your doctor for you to manage all your refills so you'll never run out. Just this morning, I had to call the pharmacy and one of my refills was up, and now they have to call the doctor, and it's like a week-long process. PillPack shortcuts all of that for you, makes the direct call to your doctor, and makes sure that when they deliver your PillPack, your refill is taken care of. It's compatible with most major insurance plans, including most forms of Medicare Part D. When you sign up for PillPack, they make sure that your insurance is compatible before they transfer any of your medications over, and switching is easy. You sign up on their secure site, and they take care of everything for you. It's been recognized by Time Magazine as a top 25 invention. Jill Duffy gave it a great review in PC Magazine, who named PillPack an editor's choice health service. There's also a PillPack medication reminder app for the iPhone and Apple Watch. PillPack is simple, convenient, and modern, and you won't believe how cool it is until you try it. So here's what I want you to do. Visit pillpack.com/twit to sign up now. Their site is beautiful, and it only takes 5 minutes to sign up. When you use our link and transfer your prescriptions to PillPack, you get a credit for $20 worth of vitamins and over-the-counter kind of supplements. So go check it out at pillpack.com/twit. Thank you so much, PillPack, for organizing my many medications and for being a sponsor of This Week in Law.
So obviously the next step for that is to, integrate with WebMD so you can cough into your phone and get your, hypochondriac's medicine through the mail next.
That's right.
Hey
Stay
Denise,
tuned.
can we see that bag again?
Sure. Wait, there you go.
So I don't mean to be overly
organized
intrusive.
one or the unorganized one?
How many hours a day do you spend popping pills?
This would be for a lengthier trip. And
okay.
This is not one day's. No, this is several days accumulation of things that I take. But I probably take about 10 different tablets in a day in a morning when I get up.
I'm surprised that'll make it through the airports. Surprised you can travel with a big old bag of pills.
You can. They're all perfectly legal, and some of them are even prescribed for me. And Emory, when you get to be my creaky old age, you'll have to take those glucosamine, chondroitin, and other things to keep yourself moving along at the pace that you've become accustomed to. All right, let's see, where were we going? Oh, we were going to the blockchain, which, longtime listeners of the show will appreciate that several years ago when Bitcoin first appeared on the horizon, Evan Brown, my then co-host, remarked at the time, this thing will never last. This thing is going nowhere. And it had sort of a meteoric rise, and we liked to rib Evan and chuckle at him. This last week, I just got an email from him. The subject line was just C with a question mark and linking to an article in Time Magazine describing how one of Bitcoin's developers has a lengthy post on Medium outlining why he thinks Bitcoin has completely failed. The fundamentals are broken, and whatever happens to the price in the short term, the long-term trend should probably be downwards. I will no longer be taking part in Bitcoin development and have sold all my coins, says Mike Hearn. So Evan feels vindicated. I know we have some very Bitcoin and blockchain-oriented guests coming up, Emory, so I don't want to spend too much time on this, but I just wanted to get your take on Mike Hearn's post here.
Yeah, I mean, there is a lot to unpack here, and I guess we should talk about this specific, the Death of Bitcoin article, while it's still not, timely news. But yeah, where to start on that? Bitcoin has been declared dead every other month since it was created. And Mike Hearn is a controversial character. He's I think undoubtedly a very intelligent developer. But as far as how much development he actually did on Bitcoin Core, I think the GitHub releases show he's way, 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 way down on the list of regular contributors to the code. And the Time article is just kind of incorrect. Really, Bitcoin is going through a really, really interesting period of its life cycle right now. So a whole part of the Bitcoin experiment is the idea of creating a totally peer-to-peer economy and a decentralized open source economy almost. And what this is showing is it's showing some real growing pains as the community is not exactly in agreement about how Bitcoin is going to proceed moving forward. Make no mistake, Bitcoin's $6 billion industry right now. It's not dead. It still works. It still works exactly as it was intended to work, and people are using it every day. The question is coming up with some really interesting ideological questions of where Bitcoin is heading, how centralized certain aspects of Bitcoin are in the future. And those are all very interesting, but in a lot of times very subtle questions that deal with high economics and high political philosophy. And I think that the community, especially the Bitcoin community online, it gets very polarized and very intense. And there's a lot of people that probably because they have money invested in it are very energetic in their views. So, I think that the technology has shown itself to be resilient and shown itself to be novel and useful. And there's applications that people are talking about developing to fix problems that they see with X, Y, or Z part of it. In the long run, I think it's a fascinating piece of technology, and I think it's far from dead. I think we're going to be hearing more about it in the future. I'm not, bullish on whether it's going to be the global currency or whatever that a lot of people have said, and I may have said in the past sometimes. But yeah, it's super interesting for people to follow if you are into cryptography, encryption, digital, rights, IP, economics, philosophy. It's one of those really great everything is in it topics. So
right.
We definitely haven't seen the last of it. And Mike Hearn has also sort of spawned some controversy after his Medium post. There have been allegations that the company that he's going to work for now is a sort of big banking consortium that is working on their own private blockchain applications. Private blockchain applications are attempting to basically undermine Bitcoin and spin their own shared ledger, which really sacrifices a lot of the use and utility that Bitcoin has and the security that Bitcoin has. So, I'm not going to say about what Mike Hearn's true motivations were or not, but it's far from dead. And there's lots of people arguing about it on the internet right now. And I'm sure that whatever I've said, there's going to be people arguing about me and saying that I've said it completely wrong. So
But that's half the fun of doing the show, right? You can't say anything on the show if you can't have people arguing with you and calling you wrong.
On technology, they're very high-tempered and very convinced that whatever they're saying is absolutely right, and everyone else is literally Hitler. So.
All right. Well, let me ask you and Eric and Declan as well about something else that caught my attention in the last week. And that is that one of my favorite netizens, one of the co-authors of the Clue Train Manifesto, author of Small Pieces Loosely Joined and many other good insights about the internet itself, is David Weinberger. And I noticed over the last week that he had gotten himself a blockchain ID. Declan, what is the practicality or utility of having a blockchain ID, and should we all be running out and getting one?
I have not. I'm overall bullish on Bitcoin. I reminded of Cliff Stoll, a brilliant writer, writing in 1996 in Newsweek, saying, "Oh, this internet thing will never take off. Who's ever going to order books online or newspapers online?" That worked. That worked out well. There's. In terms of, I'm pulling up the onename.com site, blockchain ID, a better identity, get control of your identity by registering a blockchain ID. I don't feel the urge yet to link my blockchain ID and social media profiles together. On the privacy point you raised a few minutes ago, Denise, I mean, blockchains are, by definition, almost are pseudonymous and private, or public. They're not anonymous and private. These are append-only data stores. They cannot be altered. There's a full visibility of all transactions. And so Bitcoin in its current form is very non-private. It may be pseudonymous, but it's definitely not private. And there are lots of proposals, in fact, afoot to change that.
All right, Eric, any thoughts about blockchain IDs or Bitcoin and its future?
I love that we have Bitcoin as part of our tool set online. I'm probably not as bullish that it's going to become mainstream. But if it does, or if its successor does, I think we'll actually end up being better for it. I do remember someone who is worth a lot of money and someone who I trust told me a while back, if I wasn't owning Bitcoins, I was basically shorting the currency. And I just thought that was such a weird drinking the Kool-Aid about Bitcoin, that either you're in Bitcoin or you're missing out. And I'm also I don't own any Cameroon currency. I'm not deliberately trying to short it. But I just don't know that I see the kind of investment potential that I know some really smart and wealthy people saw there. If it ever does become mainstream, everyone who owns Bitcoin will end up making a lot of money. But if it remains something that's less than mainstream, it's just another tool in our toolkit. I'm glad to have it, but it is only that.
So, Emory, is the utility of a blockchain ID simply a way of verifying your identity?
Yeah. I mean, Declan had it absolutely right. The blockchain, Bitcoin at least, is pseudonymous. There was a lot of talk in the narrative around Bitcoin, in the past couple of years that it lets people anonymously buy, drugs and prostitutes on the internet or whatever. But that's not the case at all. Bitcoin address is, a pseudonymous string of random numbers and letters, but it's not private. And blockchain analysis, you can just track the numbers back and say, okay, well, at this point cash was purchased in this wallet, and it may have gone through 700 wallets afterwards, but there's very intelligent people that are tracking that. And on the investor point, I think that Bitcoin is way more fun for me to follow, and that I'm not at all invested whatsoever, and I can just sort of sit back and be like, okay, whatever happens to the price, it's still very, very cool tech, and a very, very cool piece of crypto application. But yeah, there's a lot of really, really cool applications in development about intellectual property management or ID authentication using the blockchain. Whether or not the blockchain and Bitcoin protocol in its current form can actually support those kind of microtransactions or dust transactions, whatever you want to call them, for like actual authentication on like a large scale, is to be seen. And that's actually part of the ongoing debate in the Bitcoin community right now. Mike Hearn, for example, and I'm actually treading into, I have to be careful here, but Mike Hearn worked on Bitcoin XT, which was a supposed fork or proposed fork of Bitcoin Core that had to do with allowing or not allowing these kind of tiny transactions. So yeah, there's, where there are growing pains in the community, and the technology definitely has to evolve to get to like the next step. But yeah, as far as authentication purposes, I think that some kind of like Bitcoin ID, or I'd love to see some kind of like IP management, modular licensing, smart contracts show up on the blockchain soon, which would be very, very cool.
Yes, and I'm sure when we do have our Bitcoin expert guests on soon, we will delve into all of that. For the time being, let's look at some legislation in the making. Let's start out with the Defend Trade Secrets Act, which just had a hearing before the Senate Judiciary Committee yesterday. Eric, first of all, can you explain what the act is for us? And secondly, did you follow the hearing at all, and any updates for us there?
Yeah, thank you. Although I'm still trying to get my head out of that funky music that we just used to introduce this one. I felt like Shaft was going to show up on the screen.
You never know.
Have you ever had Shaft or Isaac Hayes?
He's actually been on 17 times. Sorry to say.
Oh man! Well, he is cooler than I am. There's no question about that.
He's cooler than all of us.
Let's talk about the Defend Trade Secrets Act. And I've called this particular bill the most important intellectual property development that you're not paying attention to. It's a pretty simple conceptual move. The idea is to introduce a federal civil cause of action for trade secret misappropriation. It fills a gap in our intellectual property protection that has been around for forever. We have a federal criminal law for trade secret misappropriation, meaning the government can bring federal cases. And we have state laws allowing for civil causes of action where trade secret owners can go into court and sue. But trade secret owners can't sue under a federal law because there's that gap. And the Defend Trade Secret Act would fill that gap by creating for the first time federal civil causes of action for trade secret misappropriation. If I were designing the law from scratch, I would create a federal civil cause of action for trade secret misappropriation. So in that sense, I think the law is logical to fill that gap. But we aren't starting from scratch. And the consequences of creating that law have a bunch of ripple effects for trade secret owners and for people who are quote, consumers of trade secrets, whether that's companies hiring employees who might have trade secrets that they're bringing with them, or companies that are receiving information under a non-disclosure agreement, or companies that are working together on some kind of joint development. A federal civil law is going to create a bunch of implications for those circumstances. And that makes the law really, really important, even if it's just, quote, filling a gap that has existed for a while. The law has gone through several hearings. There was one yesterday. I have been trying to keep abreast of new developments in the law because I've taken a pretty active stand about the law. And as usual in situations like this, there's definitely two levels of information disclosure. The insiders get better information than the rest of the public at large. And I'm not an insider. So I actually have not heard what transpired at yesterday's hearing, although I have been trying to figure out what happened. My understanding was that a new amended version was introduced at the committee yesterday, and I still have yet to see that, despite my trying to find it.
All right. Well, if you can't get eyes on it, I'm sure none of the rest of us can.
Unless you're an insider.
Yes, not like Sarah Palin here. I'm just looking in from the outside. I think that's the only way I could say I'm like Sarah Palin. Declan, any thoughts on this act?
I am delighted to say that as someone who's focused on a startup, I have not followed the hearing. I have not read the legislation. The only thing I've read is David Post's useful article on the wallet conspiracy. And after I've interviewed David over the years as a reporter, and I tend to agree with him on copyright and IP issues broadly speaking. And he's saying that he's excerpting the portion of the bill talking about based on an affidavit, the court may issue an ex parte order providing for the seizure of property. I mean, this is kind of worrisome. So at the very least, I'll support embracing this principle for every law in this area enacted. How about repealing one as well? And we're still waiting on Section 1201 of the DMCA reform, repealing that anti-circumvention section. If the IP lobby wants this, maybe they should give up something as well.
Good point. Emory, any thoughts on this one?
Yeah, actually, I spent a little while yesterday diving into that rabbit hole. I didn't really have any idea that the trade secrets space was so important, and IP context. I did look through the bill. My takeaway from it was that the ex parte hearing sounded like it had very, very strict requirements for granting it, but the real problem with this DTSA sounds like it's not preempting the state laws, so it's really going to let people double dip. And that seems to be the problem. Like, I don't really have a problem, philosophically with the idea of a federal trade secret unified law. It sounds like that's sort of what we were trying to do with the Unified Trade Secret Act, right? But the way this is currently set up, if it's not going to preempt state law, trade secret owners are going to be able to sue in federal and state court. And just like Eric was saying in his article, that just means that there's going to be more victories for trade secret owners. It seems like a really big club to wield that probably could have been refined a little bit better. But obviously, I'm going to defer to both of our other guests here for their expertise here.
Eric, is there a political season angle to this law as well? Obviously, it's a U.S. law, a proposed U.S. law. It's going to apply to U.S. citizens and those doing business here, but there is a lot of hand-wringing over foreign nationals appropriating the trade secrets of U.S. companies. Is any of that addressed in this proposed law?
So anytime that we talk about protecting U.S. companies nowadays, in Congress, it's always about we got to stop China. So China and ISIS are two of the most popular bogeymen in the D.C. corridors of power today. And when it comes to things like trade secrets, we're definitely concerned that the Chinese are stealing our good stuff. And I haven't really seen clear empirics that help defend that statement. There's no doubt that there is Chinese espionage of our corporate activities. And I'm pretty sure that there's U.S. espionage of Chinese corporate activities as well. And so, but we never want to talk about that because we're only the victims here. But definitely there are some concerns about the Chinese theft, and that rhetoric has come up a lot in the discussions about the Defend Trade Secrets Act. Although, to be honest with you, the law doesn't really address or solve any of those perceived problems very clearly. In the end, let's assume that you can win your case in the U.S. court. If you still have to go to China to get them to enforce it, you're still not really making a whole lot of progress. And we do have a federal criminal law that would apply to various types of government espionage of corporate activities. So if anyone is a Chinese spy trying to steal our good stuff, they still are at risk of going to jail for that. I will point out that the ex parte seizure provision that Emory mentioned is partially designed to address this problem. The idea is that there's some Chinese national who's gotten their hands on the good stuff and they are bolting for the airport. And so we need to have some legal authorization to go and tackle them before they get through security and get onto that plane. And the rhetoric behind the ex parte seizure provision has been very squarely directed at let's grab the Chinese bad guys before they hop on a plane. The law does nothing to actually advance that interest. That's a complete red herring. But the rhetoric is certainly being used.
I feel like that's the theme of the day, really, the rhetoric not matching the application. And when we're talking about backdoor encryption or the DTSA, these are, boogeyman issues. It's, I feel like, again, any technologists, if you ever hear politicians say, terrorism or for the children, immediate red flags should be going up left and right. Because, it's, criminals aren't breaking the law because of a lack of law. They're breaking the law because they can get away with it. And I don't really see how this ex parte seizure does anything to prevent that either.
How do you know a politician is lying? Their lips are moving. But
yeah, and I mean, both of you have hit on why we do the show every week. It's a place for people to come on and have lengthy discussions that go beyond the sound bites and try and look at the policy from angles that might not get on the national news. So I'm glad that you all are joining us and becoming more informed. Let's thank, we wouldn't be doing the show without all our sponsors. So let's thank our final sponsor before we get into another piece of pending legislation that affects consumers and their ability to review things and research things online. Our final sponsor for this episode of This Week in Law is FreshBooks. If you're a freelancer or run a small business, chances are your least favorite part is rummaging through receipts, trying to keep track of your expenses, creating, formatting, and sending invoices, and the worst, tracking down customers who don't pay you on time. FreshBooks is the super simple cloud accounting software that's giving thousands of businesses like yours the tools to save time billing and get paid faster. I use FreshBooks in my law practice, and thank goodness I do, or else my law practice would grind to a screeching halt. Because it is so easy to use, because it is so professional that I don't have a moment's concern about sending it out to my clients. I know it makes a great impression, and I know that for me, it's very streamlined and helps keep me on track both in recording my time and making sure that when it's time to ask my clients to pay me, they get the most accurate and professional presentation of a statement possible. So you'll be creating and sending invoices just like I do in minutes and get paid online right away with FreshBooks payments. You can get paid up front now. You can request a deposit in FreshBooks. No more covering costs out of pocket or waiting till the end of a project to get paid. Plus, FreshBooks just announced their new card reader. Now you can easily accept credit cards wherever business takes you, quickly and securely, right from your iPhone in less than a minute. FreshBooks card reader is EMV chip card enabled, the new standard in the US. With their entirely redesigned iPhone app, too, you can now conduct business anywhere. You can send an estimate right after the handshake. You can send an invoice in seconds right on your phone. It's so easy to track all your billable time. And now you'll know how long your projects really take. Throw away that shoebox, please. Track expenses on the spot using your phone's camera. Hey, phones have cameras. Who knew? So why do you need to keep track of receipts? Keep track of them electronically and let FreshBooks do the rest. All this allows you to focus on what you love the most, growing your business. You'll wonder why you didn't start with FreshBooks sooner. If you have questions, help is free forever, and you can always count on FreshBooks award-winning support rock stars to go above and beyond whenever you need a hand. Getting started is simple, and it's totally free for 30 days. Go to freshbooks.com/TWiL, and don't forget to enter This Week in Law in the How Did You Hear About Us section. Start your 30-day free trial today. Thank you so much, FreshBooks, for your support of my law practice and of this episode of This Week in Law. All right, let's talk about the Consumer Review Freedom Act, which appears a more friendly to our panelists, I think, piece of legislation that is also gaining traction in Washington. Can you tell us the status of it, Eric, and also what it is?
Yeah, sure. So it's kind of hard to even imagine, but there are some businesses that have tried to stop their consumers from reviewing them online. They've done things like, say, in their user agreement or their service contract, you may not talk about us online. Or they've done things like create fines where they say, if you talk about us online, we will fine you. And if you don't pay the fine, we will ruin your credit. Or they've done things like say, if you ever write a review, we own that review and we can go and control the review and remove it from the internet if we don't like it. All of these things are such a gross abuse of the customer vendor dynamic that it's hard to believe people do it. And yet we're seeing over and over again, businesses think that they've got some clever way of trying to manage their online reputation and game the system somehow so that they look better to their prospective customers. So Congress has proposed banning the practice of stopping your consumers from writing about you online. The law is called the Consumer Review Freedom Act. It was introduced in both the House and Senate. In December, the Senate passed a version, so the action has now moved to the House, where we're hoping that the House will take up this bill and move it forward, get it passed as well, and send it over to the president for signature. There's not really been any organized opposition against the law. I think everyone gets the idea that it's just ridiculous for businesses to try and stop their customers from talking about each other. So really the only question is whether Congress can pass a slam dunk law, and it's only a sign of how difficult it is to get things through Congress that something like this hasn't passed yet.
Declan, do you think that it's the case that this is a good area for Congress to legislate in, or should businesses just be able to hoist themselves on their own petard if you're going to pursue the kinds of draconian practices that Eric described? You're not going to have customers very long unless, I suppose, you're in an area where you're sort of the only game in town for whatever product or service you're providing. What's your take on this?
Well, I'm glad I finally get to disagree with Eric on something. I do it advisedly. Eric is a formidable opponent, but he's wrong on this. I mean, you just put your finger on it, which is that if businesses do stupid things like this, they'll actually lose customers even without our friends in Congress, who, as we know from our discussions about encryption and anonymity, are always on our side helping them out. I tend to be libertarian on this point. I think adding such language to terms of use agreement or contract would be stupid, but let's let businesses be stupid and pay the price. We don't have to have a nanny state established for this. Let's say that a dentist is really, really good. He only takes the most difficult cases, and 10% of cases there are some screw ups, and then people post all these nasty reviews saying, "Oh, this is the worst dentist ever." In fact, where again the facts are he's very good and top of his profession, and then the dentist hires another employee and has to respond to these reviews, and then has to raise rates for this, and then he says, screw this. I'm going to put something in my contract saying no reviews. I'm going to cut my prices by 10%. Sorry, new employee. This is something where consumers are actually better off, but that will be prohibited by this law. I mean, maybe this is a contrived hypothetical, but law professors would know nothing about that. The point is that there's no need for Congress to regulate, and I don't even know where. If we're talking about restricting contracts in just a local area that's not necessarily interstate commerce, I'm not even sure where Congress would have the constitutional authority properly defined to enact such a law.
Eric,
I don't know.
what do you think about the authority line of argument?
I'm still reeling from the fact that Declan and I don't agree on something today. So I don't know how that happened. Wow. That was from left field.
It makes the discussion more interesting, but you're wrong.
No, I'm glad that we have something to spar about, but I'm a little surprised about this one.
Yeah.
If I can just briefly introduce another libertarian perspective, the libertarian perspective could also be that in order for consumers to make smart choices in the marketplace, they have to have robust sources of information. And so a business that tries to distort the flow of information is actually distorting the overall efficiency of the marketplace. So to me, actually, this law is really very squarely designed to advance a market-based economy and a libertarian perspective of letting the marketplace sort the problems out. Sometimes libertarians don't all agree with each other, but I'm a little surprised here to hear a libertarian critique of this that is at its core ultimately suggesting that it's okay for people to distort the information in the marketplace. That doesn't make any sense to me. As for Congress's authority to enact this, because of the fact that we are talking about information that informs the marketplace, it actually seems quite simple that this would fall squarely and unambiguously under Congress's Commerce Clause authority.
Right.
Right.
Yeah,
And
I think I'm on Eric's side with this one. I think that my advanced contracting professor would have a field day with this. I'm definitely going to bring it up later this week. But my fear is that, I'm reading through Eric's letter here, and it looks like there already was precedent to support these kind of really ridiculous clauses. My fear is that consumers are already not reading through their contracts. Boilerplate contracts are already so common that I see this becoming commonplace. If this is allowed, then it's so easy to just add it into your form, and then suddenly you're not allowed to go onto Yelp. So I don't know. This sounds really, really nefarious.
Eric, I know you've...
Emory, if I can just pine upon that. My take is that the law is pretty clear that businesses can't do this based on contract law and unfair competition law and some other legal doctrines. The congressional action would just move everything up and make it cleaner to tell businesses not to do it. I think we're going to reach that result even if Congress does nothing. It just will take us a bunch of extra years to get there, and there'll be a bunch of problems in the interim.
Gotcha.
That was my question. You've followed these cases closely when people have challenged these kinds of restrictions. And I'm wondering how much success they've had on balance in the laws as they exist today, whether you're arguing that that particular clause is unconscionable or it's some sort of unfair competition, et cetera, to insert language like that in your contract.
This is a really good example of why sometimes it is better to have legislation than to let things evolve through the common law, where the courts build a set of legal precedents that create a clearer line eventually. Because we haven't had that many cases over these types of, quote, gag clauses in court. And to the extent that we've had them, we haven't had really that many clean rulings that help us understand exactly where the legal line is. Most courts have been pretty skeptical about the clauses, and in some cases that's led to favorable outcomes for the consumers who want to write their perspectives. But we don't even have, I think, the definitive legal precedent in court, and it could take us years until we get that. So that's again an advantage, I think, of the statute. We just get to the inevitable result. We just get there cleaner and faster. And the only caveat I'll add, there was a case that I've been using as a good example of how difficult this issue is, where online vacation rental or vacation rental you could do online, landlord put in place a clause saying you couldn't review this rental. And at least two of his customers violated that contract provision. So the landlord sued the short-term tenants for having reviewed in contravention of the clause. And the court said that the reviews were not defamatory, so it ended the defamation claim, but it held open for further scrutiny the breach of contract claim. The court said, I see a contract. The tenant said they weren't going to review it. They reviewed it. Therefore, I need to take a closer look at this. And so to me, those are the kinds of rulings that just make me scratch my head and wonder why we wouldn't want to just have a clean, decisive rule. Because in the end, I think that the landlord's going to lose, but we spend so much more time adjudicating it at substantial cost.
All right, Declan, are you persuaded that perhaps this particular piece of legislation just sort of echoes the law as it already stands and will help clean it up a bit?
Well, unlike Eric, I trust the courts to get this right more than I trust Congress, because, you know, by the time the pure law professor version makes its way through committees and a conference committee, you're going to have who knows what added to it. The courts are look at something in detail and aren't subject to the same kind of special interest lobbying and log rolling that you have in Congress. I'll trust them. I'm also not sure that it's the libertarian impulse is to regulate a dentist in Hawaii who only treats patients in Hawaii, somehow call that interstate commerce and start banning types of contracts that this poor dentist can offer. But I admit that most courts would agree with Eric's definition of what's allowed under the interstate commerce clause here. Not sure, so I agree with him on what's likely to stand. I disagree with him on what's more libertarian.
All right. Well,
and I'm sorry, I just have to point out that somehow Declan maneuvered me into being a pro-Congress supporter here. I don't know how you did that. That is about as wacky as it could be. I will tell you that I've read the bill. I've read what happened in the Senate. I think that the amendments from the first draft to the Senate approved draft were actually an improvement. So I actually think this is a good bill, and I would say that quite rarely.
All right. Well, I think we have to make Speak Your Mind our final MCLE passphrase for this episode of This Week in Law. And move on to our tips. You get 3 tips for the price of 1 this week, and our resources of the week. Our tips, as I said, we have a few. The first, I just sort of unearthed with the help of our panelists right before the show started today. Declan and Eric and I were all having trouble with Skype, so you may find that you are too as a result of a recent update, and may have some trouble logging in. We managed to overcome that hurdle, but in the course of that conversation, we were talking about ISP masking in Skype. Declan, can you tell folks why someone might want to use that and how they would go about turning it on?
If you are using the latest version of Skype, I think it's version 7.x, then if you go to the app preferences, this is on OS 10, and then go to the advanced, there's an option for allow direct connections to my contacts only. And if you're talking to someone who's not a contact, then your IP address will stay hidden, which, in other words, if you're talking to someone you don't know well, then your IP address will be cloaked, which some folks might care about.
Yes, that's a good thing. So we wanted to make you aware that that's available. Also available, though, we passed this one along as Lifehacker did with a grain of salt, is a script that will enable you to detect and disable a rental's hidden Wi-Fi camera. If you're staying in an Airbnb or a VRBO or in any other property that is not your own, you might be concerned that the owner or maybe a previous tenant has put a hidden camera there that could be watching your activities in that rental. In the sharing economy, maybe things are looked after a little bit less than it might be in a hotel. This might work in hotels too, I'm not sure. But this is a script. Again, it was written up at Lifehacker. You can find the link to it and everything else we've discussed today in our discussion points at tagpacker.com/user/thisweekinlaw. But what the script does is it goes on to the Wi-Fi network, finds any hidden Wi-Fi cameras and turns them off. So that might be something that you'd like to be aware of. The caveat is that the FCC made some changes last year involving messing with a Wi-Fi network. And I think this was around the fact that people would go to conferences and try and run their own Wi-Fi rather than using the conference Wi-Fi, et cetera, trade shows and things like that. The FCC took some steps about that last year. And as Lifehacker points out and will point out, nobody has done a thorough analysis about whether those FCC rules might apply to messing with the Wi-Fi network through this script. So caveat scriptor.
I've had to actually fix some Wi-Fi networks at an Airbnb that I've been at before. So it's always fun getting to the Airbnb and seeing the little post-it note that has the Wi-Fi password and realizing that their network's not working. I just take it to myself to fix this and let them know. But I've probably broken the law by doing so.
Tech support, but possibly not legal tech support. So our final tip is beware of low-flying Ubers. Our show last week, we had a lengthy discussion of Uber and sharing economy economics, and thought it would be worth pointing out, in case you hadn't seen it in your news feeds this week, that Uber is moving into the helicopter business, and specifically launching helicopter rides at Sundance. This coming week is the Sundance week in Utah, and presumably elsewhere if they're doing it in Utah. So what could go wrong? Uber and helicopters.
This is why I use Lyft. Come on. This is exactly the sort of thing I was talking about last week. Can you believe this? Uber X, Uber Black Cab, Uber Limousine, and Uber Chopper.
Uber Chopper. Yes. So, if your credit card limit is high enough, I guess you can get wherever you want, however you want, using Uber. That'll be something interesting to watch. Eric, any regulatory or FAA other safety thoughts about Uber Chopper?
Sorry, no, I haven't looked at that one yet.
What about you, Declan?
No, I love it. It's I'm a pilot myself, fixed wing, not a helicopter, and so I think this is grand. It's meeting market demand in kind of a funny, sometimes somewhat over the top way.
What do you think they'll move into Uber Private Pilot, where you might be able to hang a U on the window of your single engine Cessna?
Well, actually, which is actually what I fly in some other similar planes. You're getting into an entirely different regulatory thicket of when private pilots can have people riding with them and splitting the fare, and the FAA has not really been all that some startups in this area have failed because of government regulations. It would be more like commercial pilots splitting the fare, and so I certainly hope so.
I had actually was just reading about that today. I was under the understanding that the FAA explicitly prohibited this kind of setup. Do you know how Uber is getting around this? I mean, presumably Uber is doing the same thing they did with the cabs and saying that we're not a cab service or a transporting service. We're just a social network to connect, drivers to riders. But when you get into the FAA and those kind of regulations, I would imagine that would throw a significant wrench into this operation.
It's pretty easy to get around it. You hire commercial pilots who are flying aircraft that are certified for commercial use, and then you can do it's just a private charter flight that the sort that's existed for decades. The problem comes, and this is a different topic. If I am flying, say, from the San Francisco Bay Area, say out of Palo Alto or San Carlos Airport down to LA, and I'm looking for someone to share the cost, can I do this? And can I do this as a private pilot, or do I need a commercial license? That's where it gets tricky, that edge case.
That sounds awesome, actually. I had never even considered that. What a great way. Totally converted me right now. That sounds like a really great idea.
And in this, at least Uber's press release says they are partnering. They're not just sort of bringing in Salt Lake City idle chopper pilots to service Sundance. They have partnered with A3 by Airbus and Air Resources, and presumably are only using pilots through those outfits for now. But it says all air services advertised will be provided by Air Resources. So there seems to be some sort of at least intermediary corporate step between the pilots and the customers in this particular instance. Our resource of the week, again, this is something that Declan linked to that I found fascinating and useful, and I hope you will too. It's from the Daily Dot, and it is 10 anti-surveillance tools that protect your privacy online. It has a wonderful graphic of something that looks like the monsters from The Matrix, except for instead of things that are going to cut open your spaceship, they have cameras at the ends of the tentacles. Anything in particular you want to highlight here, Declan?
That was recommended by the world's greatest news app, which you can download for yourself at reason.io. I think it's a good roundup of technologies. The author, Patrick O'Neill, has been writing a bit about, or more than a bit, writing frequently about surveillance, and it's turned into a good site for topics about privacy and the NSA and so on. I'd really recommend reading the whole thing.
Yeah, it's actually, you see these kind of lists fairly frequently, and this one is updated with, up-to-date current information, new recommendations that I hadn't actually really paid much attention to. I do want to shout out specifically to Signal. That is such an incredible app that if everyone would use, it would just be amazing. Open source, audited, cross-platform, encrypted, text messaging, and VoIP. So check that out in particular, please.
All right. Good. Hey, Eric, I wanted to touch base with you and have you let us know how Lisa's doing and your family as she continues to battle one of the 5 most common kinds of cancer that people can get, lung cancer.
Yeah, thank you for asking. The good news is that my wife has been stable. She's taking a gene therapy drug called Xalkori. It targets her particular cancer mutation. Xalkori is an example of how pharmaceuticals can make our lives better. And it's been working for her for a while now, and we're really grateful for that. If I can do the plug, my wife does blog about her journeys with lung cancer at lisa.ericgoldman.org. And I apologize if this is self-serving, but her blog posts are just beautiful, and they're heart-wrenching. And I hope anyone who has familiarity with lung cancer, or even more importantly, if you don't, I hope you'll take a look and see what the journey is like for someone who you would have said is the least likely person to get lung cancer.
Yeah, absolutely. That's why Lisa's story has always resonated so strongly with me. Is I'm not that familiar with lung cancer, even though it is one of the 5 most common. I believe colon, lung, breast, ovarian, and skin are what most people have to contend with. But you don't think of people contending with lung cancer when they are healthy and strong and not a smoker, and that's all your wife, correct?
Yeah, right. She was a never smoker. She was 41 at the time she was diagnosed, and she had been a fitness instructor. She was teaching spinning and Pilates. She was a vegetarian. So she didn't match up on any of the risk factors that you would associate with getting cancer, let alone lung cancer. I will add that lung cancer is the biggest cancer killer by far. So of all the different cancers you mentioned, the one that kills more Americans by far is lung cancer. And even the segment of lung cancer victims who have never smoked would be one of the most sizable populations of lung cancer deaths if that was separately broken out. So even though we associate lung cancer with smokers, the number of Americans getting lung cancer who have never smoked is still a really large population of the overall lung cancer deaths.
The other terrifying thing about lung cancer is all the other ones I mentioned. There are at least methods, and they're varying in their efficacy at detecting, but there are methods for early detection and monitoring to see if you're susceptible or if you might have something that's precancerous and needs to be dealt with. Is there anything like that for lung cancer?
No, and that's one of the reasons that lung cancer is such a killer, because so often it's identified once it's spread quite a bit. It also is very difficult to eradicate. Once it gets in the lungs, that's a really good environment for fostering the growth of cancer cells. But the main reason it's such a killer is because there is no good early detection method. Contrast that with breast cancer, where we've made such good progress in saving women's lives and some men's lives by early detection through mammograms. And so you can see the difference in the 5-year survival rates for breast cancer versus lung cancer. 5-year survival rates for breast cancer are now over 90%. Survival rates for lung cancer of all types is about 17%. And for people who are designated with stage 4 lung cancer, we get into a very small percentage of them who can survive for 5 years.
Right. Well, thank you for all the good information. I will go ahead and emphasize my elderly state by letting people know that I engaged for the first time yesterday in one of those other early detection methods for colon cancer. Had my first colonoscopy yesterday, and it was very uneventful and very easy. So if anyone has doubts about whether they should be doing that and they are of the age when they really should be, I'm here to tell you it's easy peasy. Great way to basically spend an afternoon not taking care of all the other details in your life and letting people take care of you for a moment and do some really effective cancer screening. My doctor mentioned that while not all colon polyps develop into cancers, every cancer of the colon invariably develops from a polyp, and that's how they find them, is doing these tests. And the other thing I'll mention is we were just referring to that graphic of the thing that looked like the monster from The Matrix. It was a very pleasant and easy experience, but when I did go into the procedure room, there was a shelf of hoses hanging down that looked like they could very well come to life, like that monster from The Matrix.
Let's keep it in a cabinet. I don't need to see it. Let me turn around and,
those scopes in a cabinet. But other than that, it was super easy. And I definitely encourage people to go out and get it done if you're of that demographic. So with that, we'll go ahead and wrap this episode of This Week in Law. So excited to have Declan MCCULLAGH on the show for the first time. So excited to have people learn more about Recent, Declan. I've been using it myself, and I agree with you. It's a fabulous, fabulous tool. And I can only be grateful that you've put it out there, and wish you all the success.
Thank you. This is very kind of you to say, and it's free at recent.io.
Wonderful. And Eric, thank you so much for joining us yet again. Never not awesome. It continues the streak. Anything you want to let us know about that's going on at Santa Clara before we go ahead and wrap?
I'm actually on sabbatical this year, so I'm a little bit out of the loop. But it's such a pleasure being here and participating in this. It's a fun show, and I had a lot of fun today.
Wonderful. We had fun chatting with you. Emory, great to chat with you. And we're going to be dark next week, but I'll see you in a couple of weeks. Anything you want to let people know about right now and during our break?
No, nothing really comes to mind. I want to thank you again for having me on the show, and thank both of our guests for coming on the show as well. It was a great discussion. I'm glad we could talk about this stuff. I hope I contributed something of worth.
You did, very much so. Thank you so much for taking the time. If you have taken the time on a Friday at 11 o'clock Pacific time, 1800 UTC, that means you've joined us live. And we're so glad that you've been able to do that. We encourage people to do that. That's when we record the show. It's fun to have an audience while we do the show. You can jump in our IRC and join us and heckle us and ask us questions and fill in the blanks when we forget things, which happens all the time. So we really appreciate it if you can join us live, but don't worry about it. If you can't, you can find our entire archive of shows, including episode 10 and every subsequent episode that has featured Professor Goldman, at twit.tv/TWiL. I'm not saying that every subsequent episode has featured him, but you can find the ones that did. And you can find our episodes also on YouTube if you prefer that outlet for your viewing pleasure. And in fact, if you go to twit.tv/TWiL, there are all kinds of ways you can enjoy the show, whether on your phone, via iTunes, via Roku, if you'd like to kick back on the couch and watch it on TV. Lots of great ways, and they're all laid out there. So we're just glad you can join us however you do. I'd love for you to get in touch with me between the shows. Let us know what you have thought about the topics that we've covered. Suggest guests that we might reach out to. Let us know about developments that you think I might otherwise miss, and I guarantee you that I do. So it's really great not only to have things coming my way through the Recent app, which they do, but also from our viewers and listeners who scan their own news gathering sources and realize, hey, this would be a great story for This Week in Law. I'd love to hear some experts talk about this in greater detail. We love getting that kind of feedback from you. So please send it to me at denise@twit.tv. Find me on Twitter and send it to me there. I'm D Howell. Or look up one of our social media pages, which exist on both Google Plus and Facebook, and reach out to us that way. And as I said, we are not going to do the show next week, but we will see you in February. Thank you so much for joining us on This Week in Law.